Thank you, Mr. Chairman, for holding this hearing. Thank you, Director Osuna, for being here today. You know, the 700,000 Texans that I represent are certainly concerned about the impacts of illegal immigration in this country and what many see as an environment of lawlessness created by this administration when it comes to the enforcement of our immigration laws and, frankly, the inefficiency of our immigration system. And one of the things that highlights that is a fact that was related by the chairman, the fact that there are approximately 459,000 immigration cases waiting for action right now. And, you know, it would appear that that type of backlog of cases really amounts to de facto amnesty because it allows individuals that are in this country, perhaps illegally, to remain here without any repercussion as their cases are stuck in administrative limbo. So I'm anxious to hear some of your testimony today about your plans to reduce that backlog. One of the cases that I want to ask you about in terms of contributing to a backlog is one of the judges in the Houston Immigration Court, Judge Mimi Yam. Are you familiar with Judge Yam?
Yes.
All right. Over the past 5 years, there were a total of 24 months in which Judge Yam failed to issue a single ruling. Were you aware of that?
Not to those specifics, but I'm aware of the issues there.
And why don't you relate for us what the issues are there?
Congressman, what I can tell you is that that particular judge is not hearing cases at the moment. It is an unfortunate personnel issue that I can't get into with you in this forum, but it is true that she's not hearing cases at this time.
Well, whether she's hearing cases at this time or not, she's been paid as an employee of the United States government, and there have been long periods where, while she's being paid to do that, she's been hearing cases but not ruling on cases. And to highlight that fact, she went as long as 7 months without issuing a single decision, and through May of this year, she's issued a total of, I think, 15 decisions, where over the same period of time, one of the judges right next door to her issued decisions in 700 cases. Can you see why in an oversight hearing like this, the American people would be concerned about this type of inefficiency when it comes to ruling on our immigration cases?
Congressman, again, because I can't get into the personnel issues, we can't get into the specifics here. What I can tell you, though, is that Houston is actually one of the courts that we have targeted for adding a significant number of new judges as part of the hiring that we are currently doing. As I mentioned in my opening statement, we have added 23 new judges over the past year. The Attorney General, as of this week, had selected another 37, and we are in the process of hiring quite a few more. Houston is one of the immigration court locations, one of the immigration courts that we are targeting for more judges because of the great need there.
So, Director, we've the backlog of cases is clearly well documented. I understand that your office has shifted many of its resources to address the cases who crossed our southern border primarily on or after May 1, 2014. Would it be fair to say that the docket is primarily devoted to hearing cases involving minors and family units who were apprehended at the U.S. southern border as part of the surge?
Congressman, those cases are a priority for us, along with the cases of detained individuals. And for the reasons that I said it earlier, detained individuals are often the ones that have committed serious crimes in this country. Therefore, we move those to the top of the priority list. We make the judges and staff available to hear those cases first before all others. You are correct that last year we also added to the priority list the cases of unaccompanied children and families and others that were crossing the southern border as part of our response to the influx. I would say that a great number of the adjudications in our courts are of those two large groups. It does not mean that we don't adjudicate other non-detained cases that are pending in immigration courts around the country. We have to draw this line between making sure that those priority cases are taken care of first, but also not neglecting those cases of others that have been waiting for a long time for their hearings.
So I want to ask you about the timing in the a few seconds left here. Director, do you think it would be fair for me to say that there are presently thousands of unlawful aliens who won't have a hearing before an immigration judge for perhaps the next 5 or 6 years?
There are thousands of individuals that are waiting for their hearings. We prioritize those who need to have their hearings first because of compelling national interests, such as the need to get detained cases heard first and adjudicated first and get criminal aliens out of the country, or those who crossed the border last year. But there are others that are going to have to wait for their hearings that are because of the prioritization.
And because of that prioritization, as you've encapsulated for us, in some cases right now that's 5 or 6 years.
In some immigration courts, the wait can be as long as 5 years, yes.
Mr. Chairman, I see my time's expired. I yield back. Thank you, Mr. Chairman. Thank the gentleman from Colorado for yielding his time so I could follow up on a question, Director Osuna, that I didn't have time to ask in my prior line of questioning, and that is this. What is the official policy for granting a continuance in an immigration case?
Continuances are governed by regulation, Congressman. The regulations provide that a judge may grant a continuance for good cause. And that good cause standard has been filled out, has been outlined and defined through court decisions over a number of years. So that is the standard. Immigration judges refer to that standard, follow the circuit law and the BIA law on what is good cause, and it depends on the individual case.
Okay, so we know that that standard is established by, by case law and precedent. But the Inspector General report from 2012 cited frequent and lengthy continuances as the primary factor in this backlog that we've been talking about of now almost 500,000 cases. You're aware of that fact?
I'm aware of the Inspector General report, yes.
And the fact that they cited that as a primary factor?
I'm aware that they cited it. I can't remember what ranking they gave it, but I do remember that they did cite it.
Okay, well, to that point, the Inspector General actually recommended that your office, and I want to quote this so I make sure I get it right, recommended that your office, quote, analyze the reasons for the continuances and develop guidance that provides immigration judges with standards and guidelines for granting continuances to avoid these unnecessary delays, end quote. You remember that from the IG report?
I remember that.
Okay. Can you tell me what you've done to comply with that recommendation?
Sure. Continuances, again, are governed by legal standards. What we've done is two things. Number one is that we do provide regular training for judges on continuances. We provided a legal training just a few months ago on a number of issues. And provide information on what the courts have said about that legal standard. Secondly, this is more of a management issue, but our assistant chief judges, which are the supervisory judges that have supervision over particular courts, do monitor the continuance issue and the oldest cases that are pending on court dockets, and they take action as appropriate. Sometimes it is not appropriate to take any action because it is the number of continuances is actually appropriate in the particular case. But where there appears to be something, an outlier issue with somebody granting continuances for, other than the good cause standard, then that is treated as a management issue.
So is this having an impact on the number of continuances?
I don't have an answer for you on that, Congressman.
All right. So then let me ask you this question. If during an immigration case, the Department of Homeland Security provides sufficient evidence to find that an individual in question is not entitled to admission to the United States, what's the role of the immigration judge?
If I understand your question, I think that if the Department of Homeland Security
finds
somebody is
not entitled to admission.
Well, that's a legal determination that the judge would have to make, but certainly DHS as a party in the courtroom would have a significant impact on that decision. The judge's responsibility is to find that somebody is removable from the country or not removable. If they are removable, the evidence submitted by DHS goes a long way to proving that, because that is DHS's burden.
Well, if the determination is made, the judge's role is actually to sustain the DHS charge of removability. Isn't that right?
The judge's role is to determine whether somebody is removable, and DHS's evidence going to that fact or that legal determination is obviously very relevant, if not determinative, in the immigration judge's decision. That is not the end of the discussion in immigration court, because if a judge finds somebody is removable from the country, then he has to consider, or she has to consider, whether that person is eligible for some sort of relief from removal.
All right. So 121 convicted criminal aliens released by the Obama administration between 2010 and 2014 have been charged with homicide-related crimes. Were you aware of the fact that 33 of those individuals were released on bond at the discretion of your office after committing the original crime?
I'm aware of the 33, yes.
All right. And does that concern you?
Congressman, those cases, immigration judges held bond hearings, as anybody or most people that are not detained mandatorily are entitled to request. The law provides that immigration judges are to determine two things in a bond proceeding. Number one is the personal flight risk. Are they going to show up for their hearings, or are they going to abscond? Number two, and more importantly, are they a danger to the community? Are they a danger to others? If the judge finds that they are a flight risk, he or she may set a high bond or no bond at all. If they are a danger to the community, typically judges don't release them or set a very high bond. They don't release them. So the 33 individuals that you mentioned, I have no reason to think that judges made the wrong decision in those cases.
Did you go back and review those cases?
I'm aware of some of them. I didn't review every single case.
Chairman, I see my time's expired. I yield back.